Good morning, friends. Let's talk today the topic tort law. This is, in fact, a completely different lecture altogether because we had, so far what we had covered till the 11th lectures of law and economics, the property and contract problem, which is more or less connected and the basis of different things. In that context, contract is something to do with a non-party as well as enhancing cooperation through that contracting. So we have already seen the 5 6 principles which in fact try to build contract rationalizable. At the same time, in the property, this is regarding property. Property is always treated as the basic understanding of doing any sort of, you know, uh, business or economic transaction per se. So in that sense, that is two different legal system, or what we call the laws, contract law and property law, which is essential to have a third party transaction in economics. And all this is actually happening between known parties, whereas a tort is something, obviously the parties in the universe, they know, they are there, but at the same time they may not be knowing each other. So it is about strangers meeting with a stranger. At the same time, we don't know who is actually our other party. For example, if you are making an injury, you don't know who is actually get injured. At the same time, that will be only known after the incident takes place. So before the incident, it is completely blank. So this is completely a very different. This is actually called the stranger's deal, in fact. So you deal with the stranger only after the incident takes place. So far, we know that in the property ex ante you can determine many things. At the same time, contract too, you can ex ante determine whatever things which you can, and then you can even talk about the exposed things, what should be, etc. So, but regarding the tort law, it is always about the exposed thing because the incident is necessary, and only after the incident your case begins. So in that sense, the transaction and the normal kind of transaction is not that easy to understand. But obviously, this is having a relatively different advantage from an economic analysis point of view, which we will come in a shorter period. That is in this lecture, and the subsequent lectures are going to focus on tort law. So let's start with an example of importance of, see, if you want to, we know that the, if suppose there is an incident take place, that as I said, a harm is done. Normally harms are being dealt with punishment, that is punish the choice. So that is one way of looking at the criminal law. That is in fact the case with the regulation also. So criminal law and regulations deals with punish the choice. So you are not actually punishing the outcome. What you do in there is actually the choice itself. So for example, there is a murder happens. So what we do is actually we want to deter the murder. That is why precisely we try to basically, punish the person, not basically the outcome. You can't actually do anything with the outcome. What you do is actually the choice. The process is being tried to be curtailed. So this is the objective when we speak about criminal incidents, whereas In the strict liability, for example, punish the outcome is actually the objective. So what we do is actually the outcome itself is being punished. So that is what comes under the legal problem of the tort. So in that sense, you have done a wrong, so you are liable. So absolutely, you are talking about punishing the person and the person's outcome. Then at the same time, within this tortious case, there is another set of things which we normally called um, the negligence, where punish the combination of choice and outcome. So that is what we do. So you both punishment as well as we do both punishment as well as the punishment. We do actually punish. We do punish both the choice of that particular incident and the outcome. So these are actually things normally comes and dealt under the tortious case, and things will be more clear if I proceed with it, because this is only an abstraction in that sense. That is, choice plus bad luck is what is outcome. For example, I would like to drive a car. Okay, so my choice is to drive a car, but driving a car and accident is two different things. Everybody want to drive their car or their vehicle, whatever vehicle they are having. But if there is a bad luck, engine failure or human failure, error, there can be actually an accident. Suppose if the accident takes place, that accident not necessarily 100% by your own mistake. So bad luck and most of the things which you cannot foresee, whether you cannot foresee, because if I was driving a vehicle, then a branch falls on my car, still it's an accident. Who's liable for that? So these are the questions which we are going to discuss in the coming lecture. In the tortious case, I will discuss almost all this aspect in different lectures. So first of all, let's start. What is tort? Tort is a word which is derived from French, means injury. Okay, so contract law in India, to be as a starting note, in India, see, we don't have actually this tortious law, very strong and independent tortious law. What we have is actually your tort is being connected with contract as well as the criminal procedure, where independent tortious legislations are not there. But of course, now it is actually building up. There are many moves from the part of the legal system to have an independent kind of independent. I mean that just like the United States understanding of tort. So in that context, we have a certain limitation, because we will see that there are cases which is tried in United States, not in India. And still recently also there are, because we are all in the period of pandemic, so in the COVID case also there are certain things which we will be discussing and trialing in US, and many questions comes that why we want to actually do the same in the United States, not in India, because the answer is very simple. In the tortious laws, United States is having more stringent tortious system than in India, and we will see in the subsequent lecture why United States is having that, and why people would like to try things in the United States, and if that is the case. So many people think that this is because of something else, but not necessarily, because of the judicial setup there is actually gives you have you more options basically in that sense. That is why people want to move. Again, it seems very abstract, but I'll come to details of this discussion in the coming lecture. Okay, so contract law basically situate deals with situations where someone harms you by breaking a promise they had made. So a priori, as I started saying, a priori, you know that what are your promises and what are your expectations. No, so if that is the case, then you already entered into a certain kind of agreement. But contract law completely deals with breaking or enforcing of that agreement. But at the same time, in this case, at the same time, tort law is actually dealing with a situation where someone harms you without having made any promise. So you don't know a priori what is your opponent or the counterpart doing. So still there is an incident, that is what we call the accidental incident. So the accidental incident takes place without any promise. All right. So now what we will do? So as and when the problem comes, we have to deal with it. For that, you have to have a very different law, legal system altogether. That is what we have mentioned earlier, that in India we don't have that sort of a very strong, as and when it comes we will deal with the system. So we don't have that sort of a thing which is already been developed. But in the United States, you have a very separate legal structure which is in fact very prominent. Why I said United States? Because India and United States almost follow this common law tradition, fall under the common law tradition, and they do have a sort of similarity in many things, democracy and so many things in the legal structure. But of course, the two different the functioning of the legal system is different in these countries. So if someone shoots you, you call a cop. This example is in classical case, a classical case. That is, if someone shoots you, you call a cop. If he runs his car into yours, you call a lawyer. Why we make this distinction? Both are crimes in that sense. So see, this is absolutely making a difference between a crime and a tort. So that is again, in the accident we don't actually if you don't have a tort law, then only you immediately call a police. All right, and after the accident takes place. In India, that is the case most of the time. Immediately if there is an accident, you call a police. Police comes and get a mahasar and kind of this FIR and all, because you are treating an accident as a crime in that sense here. But in the United States, if there is a car run, of course you call the sheriff, but the point is actually inform a lawyer and you try to get your things done. See here also, but here the lawyer part is not that fast to come in your mind because of the legal system. That itself says that how good is our social system is being developed in the state. So this is what we have to keep in mind. So as always, we will be focused on achieving efficiency. In the previous lectures and all, we followed this thing. The same time, we haven't actually discounted that the fact that we don't actually consider fairness and other things. So of course we will be dealing with that. We have already dealt with that in different cases like distributive aspects, etc. So that distributive fairness and distributive justice and all we have already discussed. So, but largely what we understand as well as give emphasis is that whether the pie is being distributed completely. So that's it. So in that sense only we consider more about efficiency. Okay. Now this example will make it more clearer. That is, if I hit you with my car of do $1,000 worth of damage, okay, and you are $1,000 worth of now, right? So if I hit you, of course, one more thing which I would like to mention is that in an accident there is no construction normally takes place, that is construction of value normally takes place. Most of the time there is a destruction of value. So an accident happens means some or the other way I lose some pleasure. So I always have a negative effect of an accident. So normal case, no, most of the time this is the case, but of course there are positive things we will discuss. But no, if positive things, nobody says that it's an accident. All right, so and that sort of spillover effect never been understood. I mean, always given any priority. So in normal case, this accident itself talks about negativity. That is why this example. So I hit you means I am actually 100 or $1,000 worth of I'm making $1,000 worth of loss to you. So that means you are $1,000 worth of situation. No damage to me or my car. That is an assumption. I haven't lose. I have no damage in that sense. So if that is the situation, should I have to pay you damage? So this is the question. Should I have to pay the damage? No. In the strict liability case, as I mentioned earlier, what is the immediate response is the following. That is, I owe you of if it is strict liability, I owe 1,000. If there is no law such as liability, then I owe you nothing because I hit you, I will walk away. If there is no law, nothing. For example, in the famous incident in my mind comes, and that is in Tale of Two Cities of Charles Dickens. While the very beginning of the novel starts with this incident that a nobleman ride his cart and he hits somebody, and then he throws a penny or a coin that you filthy, etc. Rats. That's maybe the word which is, and you just deserve to be compensated this much, and he throws a coin. So this is one of the very picturesque presentation of people and the privileged, the normal people and the privileged, right? So there is no liability. It is his charity. He was throwing this coin out of his charity, and he never feel that what he has done is a crime or a civil wrong or whatever. He never feels that. So that is why he just throw a coin and say that you take it. So that's it. So this is actually comes with no liability. I am not liable at all. It is your problem that you hit my cart. So that is a kind of situation there. So but in today's world it is not like that. So in that context, I owe you nothing. So you lost, if you cripple your leg, if you die, then it's your problem, not the problem of the other person. So this is actually a situation which we call as no liability. But at the same time, you have liability rule. For example, if you hit a person, you have to pay complete compensation. So you are strictly liable. All right. Hammurabi's caught. An eye for an eye, a tooth for a tooth. Strict liability. Okay, so you are responsible for it. So this is a kind of 100% case. So I owe you 1,000, and what is the result? My payoff is 0, and your payoff is 1,000. What is the combined payoff? Minus 1,000, because that accident means negative utility. Now suppose there is another set of point that says that I owe you 50,000. Now your payoff is 49,000. My payoff is actually 50,000. Net worth is actually negative. So whatever amount which we say doesn't matter. In the zero sum understanding, so here The loss is what has been always, you know, projected as a fixed one. All right. So a tort law is basically deals with this kind of situation. Question is that how to structure the law to get people to behave in a way that leads to efficient outcome. Just like in the property as well as in contract, we ask the same question. What is our intention is to make a legal structure or a law which is actually gives us a better understanding as well as outcome of the same. So uh, in that context only we try to basically set a ground for this thing. So deliberate harm uh, make punishment severe, what we call as criminal law. So how do we know that certain harms are deliberate and certain are not? So you need a policeman. That is what, even in an accident, where irrespective of your country, you call a police person to see that what is the intention of that harm, to assess the intention of harm. There again, accidental harms, which is trickier, where the goal is not no accident, goal is efficient number of accidents. Again, so in the accident case, again, it is a very interesting way of understanding. So if you treat every accident as crime, then you are trying to say that okay, you want to punish the choice, as we said, but nobody likes that. Okay, because people also want to drive. So in that context, if you try to honor people's individuals interest, say their choices, then you have the option of whether you want to give them ample opportunity or not. So unlike nuisance law, injunctive relief is not an option here. So we know only that in the injunctive relief case which we had discussed is only good with the nuisance case. We will discuss that part also later. So unlike portion of that has already been discussed. However, we will discuss that part also in this some portion. So unlike contract law, no agreement ahead of time. Now you can't say that something is actually gone wrong because they have some sort of that kind of things which we will deal with a very different, again, part of Dorsch's case, which is an exceptionally different one, in the later lecture. And if you read the primary textbook which we suggest all of you to read, that is Cooter and Ullman, where you can see essence of tort law is the attempt to make injurers internalize the externality they cause in situation where transaction costs are too high to do this through property or contract right. This is very, very important. The attempt to make injurers internalize the externality they cause in situation where transactional costs are too high to do this through property or contract case. That is why we have tortious cases or tortious law in that tort law. Okay, so who are actually there in the picture of a tort law or a tort case? You need obviously a plaintiff who has to register a plaint. That is a person who brings a lawsuit. All right, this is what is called a plaintiff. Then you need a defendant, a person who is actually being sued, or the person who defend the plaint which was launched by somebody. All right, so plaintiff and defendant is the two party. So obviously you can understand this is in a two-party framework itself. Okay, so that is the beauty of this analysis, and we will come to know that in a shorter period. So in a nuisance case, the defendant caused a nuisance, plaintiff was bothered by it, might be asking for injunction or damage. In a contract case, defendant breached a contract or violated its term. In a tort case, defendant caused some harm to plaintiff. Plaintiff is asking for damage. Okay, and plaintiff is the victim, person who was harmed. Defendant is injurer, person who caused the harm. This is the difference. So you also say that the interchangeably we use victim and injurer in under this tort case. Why? Because a plaintiff is actually somebody who been harmed. That means victimized. As the defendant is the person who is in fact caused that victimization. So what we call is an injurer. So these two cases is there with this particular understanding, especially tort and law. And let's go to the nitty-gritty of what is the legal theory of tort deals with. Let us talk the classical, so-called classical legal theory of tort, which always talks about three things, like there should be definitely have a harm first, and then causation of the harm, and then comes the breach of duty. So these are the things which makes a classical legal theory valid. For a tort to exist, you need all these three. All right. That is, the plaintiff need to have been harmed. This is the first and foremost element in the tort. There should have a harm. If there is no harm, there is no tort case. All right. So that's it. So without harm, there is no tort. And gas company sold gas with a defective additive, for example. So there is definitely a sort of an harm. It doesn't mean that unless and until it creates a harm to the person, this company has never been sued. All right, because dangerous for car with a turbocharged carburetor. You have a car with a normal carburetor, then you don't worry, you don't sue normally. But if somebody who is actually having a turbocharged carburetor, then they do have problem. You might be angry, but you were not being harmed, therefore you can't sue the person. All right, that's the difference. So the gas additive is actually harms only for the person or the people who drive with a turbocharged carburetor. So if your car is maybe if your car is not having that turbocharged, you can't sue the person, because that is not going to be valid under the tort case. So that is as simple as it. So similarly, no compensation for exposure to risk. At the same time, you can't say that I am exposed to the risk, therefore the person is actually supposed to. So this is not going to work with the tortious case unless you have been harmed. If you are harmed, then definitely you have this chance of getting compensation. So manufacturer exposed workers to some chemicals, for example. All right. So if I am actually working with a dangerous chemical factory, I may under the contract, of course, the thing is actually nothing goes wrong. But if something goes wrong and I am get affected, then only I can actually file the same thing under the tortious case. If I am not, then I cannot. But still something is, then that is actually something to do under the contract law. So these are the strict difference between these two. So exposure will cause 50% of them to develop cancer later in life. Maybe this is the case. And the famous Marlborough case, which normally refers in any textbook or most of the articles which are written, and the compensation, the huge compensation the lady was got. All this pointing towards not this fact. Okay, that is the tortious. Because of the tortious law, only this huge sum of money Marlborough lost the case, and the lady got a huge amount. It is not because of the lady actually developed cancer, but it is actually something greater than that was being punished. That is actually the withholding of information. Okay, so it is not, the case was not being tried based on developing cancer, because there is a probability problem with that. You can't, most of the medical cases, you can't establish X is the exact reason of Y. Okay, because this organism is very complex and most of the things we don't know. So that will not stand in the court because the circumstantial evidence is has to make a point that X caused Y. So unless and until X cost Y is 100% or definite, you cannot develop stand the case in front of the court. So this is very important. Therefore, the probability case cannot on that. But at the same time, if the Marlborough case was being tried in a very positive, and it brought a positive outcome because of the other thing, which is not actually cancer, development of cancer. But we will come to these integrities in the subsequent talks. So can't you now have to wait, see who gets cancer, then they can sue. This is also the thing which we had said. So the classical theory, as we discussed, has three component. So the first component is harm, which has to be there in place a priori, because otherwise you cannot actually file a case under this. Okay. So element one, harm. Let's talk about that. Suppose this is your indifference curve and the green dot is actually your level of utility in a perfect compensation context where restore victim to the original level of welfare, generally done through money damage. What you do is actually a payment of money. That's it. In most of the tort case, you cannot, because you can't actually take a person's never even compensate the other person. Maybe in the criminal justice case that may be dealt with, but in the cautious case it is not the case, and normally this is not advisable at all. What we generally see under the tort law is that money compensation, the monetary compensation is the thing which we discuss. So look at the point. So you are initially at green, higher indifference curve, right? A point which is higher than a red, this red point, which is the lower indifference, or the orange or saffron point, which is a restored point. So under perfect compensation case, even you get a same level of monetary thing, which you may not be in the same old indifference curve. That is the thing which we are trying to understand here. So restore victims to original level of well-being, generally done through money damage. So, or this is also gives you a possibility that either you get a higher point or a lower point. But this is what we try to say. But the complete compensation is literally impossible because of other reasons. But maybe you get money sufficient for this. So we hypothetically say that, okay, let's assume that you hypothetically be compensated completely, right? And then you may be actually you may be actually in the same indifference curve only. So you cannot go beyond. So perfect compensation, but socially the other person, as we have already seen, that the other person has lost the income. Maybe the injured got 100% compensation, but that is at the expense of the injurer. So this is the point which we have to keep in mind. Now, the tangible harms can be compensable. Another point under this case is actually the tangible was an intangible harm. So medical costs, lost income, damaged property, this kind of things which we can actually compensate. Now, what about the emotional harm, pain and suffering, loss of companionship? For example, in the case of accident, you lost. If you lose a leg, you may be getting a lot of money, but you will not get your leg back. Okay, so emotional harm, pain, suffering, loss of companionship, etc., is a kind of trauma which this particular thing try to bring in. So in theory, perfect compensation should cover all losses. Historically, courts have been less willing to compensate for intangible or hard to measure losses. But these days, things are actually being tried and seen differently in some cases, but it is not a general observation normally we can refer to. So over time, US court have started compensating for more intangible harms. Now, this is a very important point. These days, that's what I said. This intangible harms are also being considered. Emotional harms, pain, and suffering. That is why compensation becomes huge compensation, because not necessarily this is medical cost, loss, thing about damaged property. It is also emotional harm, pain and suffering, loss of companionship because of the negligent behavior of the injurer. So a huge compensation is always been asked in the tortious case. What is the pros of this particular, the positive side of this thing? The closer liability is to actual harm done, the better the incentive to avoid these harms. What is the problem with it? Disparity in award sizes, unpredictability, etc. So we will be seeing different examples and papers which dealt with this sort of problem to understand this issue very thoroughly. So let us move immediately to the second element, which is called causation. So now harm is done. Now you have to also establish the causation. For a tort to exist, the defendant need to have caused the harm to the plaintiff. Now anybody cannot actually raise a plaint and launch a plaint and say that X is harmed Y. So you have to establish a cause. That is, the X is actually the reason of the injury. Now, cause in fact, this is what is called cause in fact. But for the defendant's action, would the harm have occurred? This is a question immediately anyone asks. So there are cause in fact is a defendant action, right? So there is a proximate cause, that is immediate cause, that is the in that also you have different classification of cause. For example, the proximate cause talks about immediate cause, that is defendant's action can't be too distant from the harm. Okay, we will discuss that with the case of Palsref versus Long Island Railway, which is a New York Circuit Court Appeal 1928. In that, God pushed a passenger to help him into train. Interesting example. Passenger dropped fireworks he was carrying, they went off. Explosion knocked down scales at the other end of the platform, which fell on Miss Palsgraf. Now who is liable? This is a question. Guard pushed a passenger to help him into tree. Now passenger dropped fireworks he was carrying, they went off. Explosion knocked down scales at the other end of the platform, which fell on Mrs. Palsgraf. Now you have many people. Guard is there as a proximate cause. Then the person who is carrying the firework is there as an injurer. Then the railway company itself is standing. You will see that in the vicarious liability cases. So there are different person who is actually. So who is the immediate cause? So God's action were not the proximate cause. No God knows that what you carry. Okay. But still, who is actually the reason behind it? So there are so many nitty-gritties involved in this sort of understanding, as we have seen in the contract. So again, the example of this would be much more clearer to understand. A tree fell on moving trolley, injuring passengers. One of them sued. He succeeded in demonstrating that in order for the trolley to be where it was when the tree fell on it, the driver had to have driven faster than the speed limit at some point during the trip. Breaking the law is per se negligent, so the driver was legally negligent, whether or not his driving was actually unsafe. This is if he had not driven over the speed limit, the trolley would not have been there under the tree when it fell. So the plaintiff argued that the driver's negligence caused the injury. So he sued against it. Court ruled the driver's negligence had not caused the accident in the legally relevant sense. And this is still a very important one. Breaking the law is there, and some point he was actually demonstrated also successfully demonstrated that this caused that. But still, the court said a very different ruling, that is the driver is not negligent. Now talk about the element, that is breach of duty. Breach of duty is sometimes required, sometimes not required. Under strict liability, you don't require the breach of duty, but under negligence, you need. That is, harm causation is sufficient under the accident law, which talks about the involvement. But under negligence, you require breach of duty or fault. When someone breaches a duty, he owes to the defendant, and this leads to the harm, the injurer is at fault or negligent. So injurers owe victim the duty of due care. Negligence rule, I am not liable if I failed to take the required standard of care. Not if I was careful and accident happened anyway. So hence the language in the trolley example, a tree fell on moving trolley. See, breaking the law is per se is negligence. So the driver is legally negligent. In that sense, driver's negligence caused the injury. If you try the same thing under the strict liability, he is not a strict liable person. But under negligence, of course, he has a negligent behavior. So for that negligent behavior, he can be actually. So under negligence rule, if I breach my duty of due care and injure you, I am liable. If I exercise the appropriate level of care, but still I injure you, I am not liable. This is the difference under negligence rule. So how is the standard of care determined in that context? That is, how careful do I have to be to avoid liability, and who decides? Now this is the question. It is negligent to driver in a 40 mph on a particular road at a particular time of day. What about 41 mile per hour or 42? So these are the questions which anybody can shoot up. So how is the standard of care determined in that? Of course, it is not unanswered. There is always an answer. So some settings, that is government imposed safety regulation, that are also used as standard of negligence. Speed limit for highway driving, requirement that bicycle have brakes, workplace regulations, etc. So some standards are left vague. Reckless driving may depend on road, time of day, weather, etc. So common law focus on duty of reasonable care. So in that also we have a different standard. For example, the reasonable care is one example in the common law country. Level of care a reasonable person would have taken. That is what is called ad libra. Civil law relies less on reasonableness. Test tries to spell out what level of care is required. So strict liability versus negligence. In that two different rules, you have a strict liability rule. We will discuss all the integrity. Strict liability rule, plaintiff must prove harm and causation. Whereas in the negligence rule, you must prove harm, causation and negligence. Right? A little story which is going to. In early Europe, strict liability was usual rule. So we will discuss about why this is strict liability. In the historical sense also, if we look into the importance of the strict liability versus negligence, some people say that strict liability is better than negligence, but at the same time some people say that negligence rule is better than the strict liability. But in a historical sense, there are different views in place, and you can't say that one is bad for the other, one is bad than the other. But at the same time, you can't also say that both are good, both are. No, there is a logical inconsistency. Again, for understanding that in the earlier Europe, strict liability was the rule, but in later 1900s, negligence became a usual rule. But second half of 1900s, strict liability became more common again, especially for manufacturers' liability in American consumer product. But after in 1990s or 2000 and all, people again started to believe in many articles and papers are now appearing that negligence rules are strict. Now, in my mind, it is also the rule of the game and political economy also matters in that sense. Because which side you want to actually favor is also very important. For example, the consumer court movement made actually strict liability more welcoming than the other in the later half of the 20th century. But at the same time, then again, this product producers have their own, uh, I wouldn't call it this cartel. They have their own interest group and all. Because of that, and now we are moving towards a negligence kind of. That is actually not supportive consumer, whereas and the farmer was always a supportive consumer. So, which side we are? For example, when I would like to introduce stricter liability, because I would like to actually getting part with the consumer. If I would like to support the producer in that sense, a product liability example, then I will always try to implement strict liability with the consumers favoring consumer and negligence rule for favoring the producer. So in the product liability, so the interest of the system is also very important. So I that is why I feel that it's political, because it's not actually detachable from it. So the politics as well as the rule of the or the interest of the ruling class also matters in that sense. So the next question which we would like to shoot in this behalf is also like with the contract law, our main concern is the incentive created by liability. What incentives are we interested in? The first one is called precaution, which we are going to discuss in the next lecture. Not today. So thank you very much for listening me, and I hope the lecture is a useful one as an introductory one. So in the next lecture, we are going to thoroughly deal with the precaution aspect of this thing. Thank you. Thanks once again.